All right, for more on this landmark ruling, I'm joined by SABC News senior reporter Canny Maphanga to give us a bit more on that ruling. Canny, good afternoon. Thank you very much for joining us. So perhaps for the benefit of those who have not been following, they're all now specifically beyond this ruling. This has piqued their interest. But just give us context. How does this matter find itself in the ConCourt in the first place?
So this was triggered by an application by two couples. That is Leona Theron and Henry van der Merwe, as well as the Bornmans. That is Jess Donnelly Bornman and her husband, Mr. Bornman. Essentially, you had two couples that had taken decisions regarding their family name. You had the van der Merwes that had decided that Leona Theron would assume the family name so that the husband would be taking her surname. And then you had, in the case of the Bornmans, that they were going to double barrel or hyphenate the surname. However, when both husbands approached the Department of Home Affairs to do this, they were prohibited to do so. And the legislation that was used to prohibit such a change was Section 26, subsection 1, A to C of the Birth and Deaths Registration Act, which states that only a woman can assume her husband's surname, but does not afford that right to the husband as well. So it is against that backdrop that they approached the Free State Division of the High Court, stating that this was an infringement on their constitutional rights to equality and dignity, and that the said legislation did not serve a legitimate government purpose, and that it infringed on their particular rights to give effect to the family names that they wanted to assume for their respective families. Now, because the Free State Division of the High Court confirmed that declaration of invalidity in their order, of course, for such an order to take effect, you now have to go to the Constitutional Court to get that confirmation. And of course, the two couples were able to vindicate their rights, and the Constitutional Court agreed that the piece of legislation was unlawful, unconstitutional, did not serve a legitimate government purpose. And then, of course, that defect has been given 24 months to be remedied by Parliament, and their rights and many others have been vindicated as a consequence or as a result of that order by the Constitutional Court.
Now, listening to Justice Theron in that judgment, she goes on to say that if this were left at least unremedied, it would reinforce the patriarchal norms. What else did she have to say in that ruling?
Indeed. So the Constitutional Court did an assessment on the legislation against its government purpose and the rights that the applicants were trying to assert, and found that the impact on women is actually quite insidious by this particular legislation. It reinforces these patriarchal gender norms that are rooted in colonial practices, that a woman must be expected to take on the surname of her husband, or that a woman is not in a position to carry the family name, or rather her surname carries on the legacy of her family. It puts the woman at a legally inferior position in marriage when we're all supposed to enjoy the right to equality. It's also important to note that in the court's assessment, they give you the right to do so. It's your choice. It's not something that is imposed on you. But what is incorrect is for when someone chooses to do this and then they are met with barriers through legislation that doesn't have a justifiable reason as to why it exists. And that is why the Constitutional Court exists, for many reasons, but also to remedy the defects that we identify throughout our constitutional democracy. This is not the first piece of legislation that the Constitutional Court has declared invalid or confirmed as invalid and asked Parliament to remedy the defect. This is just one of the many pieces of legislation that our constitutional democracy demands that we correct to meet the demands of the day. So what it does was it puts women and men on equal footing in marriage, and it gives women the opportunity as well to further their name, further their legacy. It doesn't create this expectation on women that they are inferior and they must now take on or be expected to take on the surnames of their husbands. And then it also affords husbands the right, if they choose to do so, to take on their female spouse's surname should they choose to do so. It's not imposed. It's just that you're ensuring that there isn't that impediment in the way should a married couple choose to take this route.
Quite progressive, but most certainly will spark a lot of debate. Canny, as always, thank you very much for sharing that with us. That's SABC News senior reporter Canny Maphanga speaking to us there.